All right, we're
Hey,
live.
yep, good to be here. Little bit of a different format for me, but I've been excited about this one for the last couple of days. So, what we plan to spend the next little while talking about is just like the title says, navigating legacies, how estate planning attorneys and financial advisors partner for success. So, we'll do a couple of intros and then we'll just jump right in. So, I'm Paul Rabalais. You may not know who I am. You may not. I think this is being played out on a couple of different channels, but I'm an estate planning attorney. Several years ago, I founded a national estate planning law firm called America's Estate Planning Lawyers. And over the years, I built up a YouTube channel, 700 or 800 videos, been viewed millions of times, hundreds of thousands of subscribers. It's been a lot of fun. My one mission is just to make sure people are educated, informed, and they make good estate planning decisions. And so it just so happens that estate planning and financial planning or wealth management, really there's a mixture there. And so I'm going to turn it over to my friend and colleague, Jacob Duke. Let him give an introduction and we'll be off and running. Jacob?
Yeah. Hey, Paul, good to be with you. I'm excited about this. It'll be a fun thing because our worlds overlap a lot. And so I'm excited about that. But my name is Jacob Duke. I'm a CFP, certified financial planner, and I own a independent wealth management practice. And so today we're just going to have a conversation. We're going to get to know each other in terms of how we can help each other, some of the shortfalls perhaps, and what we do in terms of how advisors and estate planners can work better together. Really just to give the end client what they truly need. So that's what we're here to do today. So Paul, I'm excited.
Yep, super. All right, so I want to jump in. I feel like I need to give our viewers just a big overview of the estate planning industry and the wealth management industry, and then I'm going to turn it over to you, Jacob, to get your thoughts. But my feeling is estate planning and wealth management are so related for a lot of reasons. You know, for many of our clients, their largest assets are their financial accounts, their traditional IRAs, their Roth IRAs, their brokerage accounts. And over the next couple of decades, I don't know exactly what the number will be, but it's been estimated that there's going to be about $70 million of assets transferred from one generation to the next. The bulk of those assets will be financial assets, which people who own those accounts are looking for guidance from people like Jacob and others in the wealth management industry to help them with this transition for the next generation. And there's so many issues involved in that, as we'll get to. But I feel like the wealth management industry just has this tremendous opportunity. You know, when I look at the websites, Jacob, of a lot of the large brokerage firms, and they all have a list of what they do. And it generally says, they do, retirement planning, investment planning, and always on that bullet list is estate planning.
Yeah.
And when I see that internally, I'm like, that they're really not taking advantage of that estate planning opportunity. Maybe some in the financial services industry feel like estate planning is maybe, helping someone acquire a life insurance policy or something like that. But really that wealth manager can do so much good for their clients by a little more, and sometimes maybe a lot more engagement with the client, not to the extent where they're practicing law and creating estate planning legal documents, but just engagement and participation is, I think, where they have a lot of opportunity. Give me your thoughts, Jacob.
Yeah, no, I agree. Most of us do put estate planning on our websites, and sometimes, across the advisor landscape as a whole, like you said, often that's either neglected or forgotten kind of area, but it absolutely does tie into the overall financial planning and wealth management picture because your assets will go somewhere one day. And so the way I like to say it is you're doing estate planning whether you want to or not, and you might have a really bad estate plan. So if you don't do anything, you have a plan, it's just a really bad one. And so the thing I think that advisors can help on the most there is that we have an inside look to everything, right? I mean, we see everything in terms of what we're managing, who's named as beneficiaries on accounts, because we can see that directly at the custodian, whether it's Vanguard, Schwab, Fidelity, you name it. And so for us, we, in some sense, have a responsibility to help make sure that that's done correctly. And so that's why maybe estate planning is labeled there on the website as something we do. But the key there is we're not you. We're not the attorney. We're not the people who have that that experience or that education. So for us, finding a way to partner with those people to get the best result for the clients, sometimes difficult. We're going to talk about maybe why that might be the case, but yeah, that's always the hard part, is finding a trusted person to to partner with on it and communicate back and forth really well.
Yeah, good points. And I'm looking forward to getting into the kind of mechanics of how the attorney, the advisor, the client can all work together for a really win-win-win opportunity. But maybe before that, I want to talk about, why would an advisor want to engage in the estate planning process? So some of my thoughts are, I've seen the statistics, and I'm not really quoting it here. I'm just quoting what I've kind of seen and heard, but don't quote me on the numbers. But it's something like when a married person dies, it's something like 50 to 70% of the time the surviving spouse takes that money elsewhere. And then when the surviving spouse passes away and money's passed on down to the children, the statistics are something like 90% of those children who don't have a relationship with a financial advisor wind up taking that money elsewhere. So for that reason alone, there's other benefits of the advisor and the client working together on the estate planning. Sometimes advisors can, as part of the estate planning process, find these scattered accounts, old 401k accounts, old IRAs, old stock accounts that really can make the client and the client's family's lives so much easier by consolidating all of those accounts. I always tell people when I'm having these Zoom discussions with clients who have accounts at 10 different financial institutions, I'm like, it could be a nightmare when you pass away, because now your executor, your successor trustee, your heirs have to deal with the different policies and procedures of 10 different financial institutions. And people like the idea of trying to make it easy, consolidating things where it makes sense. And so lots of different reasons. I feel like financial, and just like you said, Jacob, the financial advisor knows the client often better than the estate planning attorney knows the client. So that financial advisor can spot things that the client really, they're not aware it's an issue. But if the financial advisor spots it, financial advisors can say, hey, maybe we need to address this. Let's find an estate planning attorney, or let's work with an estate planning attorney to make sure this aspect of your overall plan is taken care of. So what are your thoughts as a financial advisor on what are some of the reasons you would engage in the estate planning process for clients of yours, Jacob?
Yeah. From a long-term perspective, as an advisor, I don't like to look at everything just like as today, right? We got to look at it over the next 10, 15, 20 years, even if we are retiring today, or perhaps we're even 85 right now. It's like, well, we've got money. Who is this going to be going to one day, and why? And so with the decisions we make now in terms of your investment allocation, even, that will be determined most likely by what that use for that money will be in the future, whether it be to fund a grandkid's education or to give it to your local charity, or like, what's it for? And identify a holistic or comprehensive view. And so in my opinion, you can't really do comprehensive planning without tax planning also included in this, but estate planning as well. And so what it does is it gives the parents, let's say they leave $2 million to kids. It gives the parents confidence that your kids are going to be taken care of if that relationship's maintained moving forward, so they don't go spend it all immediately or whatever the case is. And so for them, it's like, hey, there's a peace of mind knowing that I've got the right person on my team, along with an estate planning attorney, working together to make sure that the best results happen one day here in the future. So in my opinion, you can't do wealth management or financial advising very well without kind of all the components added in, such as estate planning. And like I said earlier, either you're doing it one way or another, whether it's good or bad, you're doing it.
Yeah, good point. All right. And by the way, I'm going to take a little pause because I've got my usuals on the live stream. I've got Larry from California. I've got Ann. They're on the call. Good to see both of you. Larry, don't worry about being late. I wasn't able to announce this live stream, but good to have you here. Good to see you. Okay, back to it. All right. Now I want to really ask, maybe it's the tough question.
Yeah.
Given that when, not in every case, but when estate plans go wrong, it's and there's many areas where estate plans can go wrong, but some of the areas where estate plans go wrong are financial accounts aren't titled correctly, beneficiary designations don't match the estate planning legal documents, which results in unintended consequences. Given the result that so much of the estate plan is integrated with how the financial accounts are handled from an ownership standpoint, from a beneficiary designation standpoint. And it's usually because of lack of communication. Yes, the legal industry deserves maybe a little blame for that. Maybe the financial services industry deserves a little blame for that. Maybe the clients deserve a little blame for that. And I'm not trying to lay blame on anyone, but given the fact that estate planning and wealth management is so related, and as you say, Jacob, it's estate planning is such an integral part of the overall wealth management process. And given the fact that we talked about a statistic, Jacob, where 93% of clients of financial advisors want estate planning guidance from their advisor, but only 22% of clients are getting it. Why do you think more advisors aren't, engaging and actively participating in their clients' estate planning?
Yeah, I think it could be a few different things. One of them being it's complex. I mean, this stuff is not easy. We didn't go to school to learn law, and that's what you're for, Paul. But maybe that's one of the things is it's scary, and to be maybe even more frank, is as advisors, perhaps we're too prideful to say we don't know, and so for us, it's like, how do we get over that? That's one thing, I think. Another thing is to be, again, quite frank with you, is we don't get paid anything extra to make sure we do that really well. Right. We're already doing our job and being paid accordingly. But again, I think it's the advisor's responsibility to at least begin that conversation and say, hey, you've got so-and-so named here as a beneficiary. Is there a reason for that that's particular? Is there something else you might want to think about there? Or your 401k, beneficiary has been named since you were 25 and you started the company, but you're 60 now. Is that the right person still? All these different questions I think come up. But yeah, I think advisors aren't incentivized in most situations to actually engage in that, because it doesn't pay them extra or pay them more, but also perhaps we just don't know sometimes exactly what to know, and so we're maybe too prideful to ask.
Yeah, well, I want to focus on that, because I feel like estate planning attorneys and financial advisors, we're all well-intentioned. We all want to see our clients succeed, and we want to help in any way we can. So my thoughts are maybe on why the advisors don't take advantage of the opportunity is yeah, I mean, you were correctly blunt, and you're saying, look, there's not necessarily any additional compensation that comes to us when we do got a client, and maybe there is some areas where you identify the opportunity to have your client acquire life insurance to create liquidity, or key man life insurance, or through the estate planning process you could consolidate accounts and increase those assets that you help manage. So there is some opportunity there to increase compensation, even by helping the client through the estate planning process. But you made a good point. And I do agree with you 100% that I think a lot of the reasons estate planning or financial advisors don't kind of jump in feet first and start engaging in estate planning conversations is because, yeah, while the advisors are fantastic at the retirement income, the investments, I think the advisors are a little concerned of like, hey, what if my client asks me this technical estate planning question that I don't know the answer to? Is that going to make me appear as some kind of inferior advisor? And so I want to talk now about how, I'm sure I'm guessing there'll be financial advisors who will watch this live stream, and you're well-intended, and you're wondering, okay, yeah, I agree, I need to do more, and I want to do more for my clients. They'd love for me to do more. I want to talk about what those advisors can do to just kind of start the process. In my view, it's just one step at a time, one client at a time, and it's really just start asking some questions. And those questions can be as simple as, do you feel like you have your estate in order? And maybe you'll get the answer, yeah, I feel like I've got it all set. Or in the likely scenario, you'll probably hear answers like, we did something 25 years ago when our kids were born, but it really needs to be updated. Or you'll hear, no, we haven't done anything. We've just procrastinated. We know we need to do something. Jacob, can you help us with that? So you're likely to hear, yeah, I want some help, and can you help me? So just starting to ask questions. Do you feel like your estate is in order? Do you have any specific intentions on how you want to leave things behind? How do you want to provide for your spouse? How do you want to provide for your kids? Do you have any unique family circumstances that would warrant, us addressing these things? And the advisor just needs to be a good listener. They don't have to have all the answers, but they just have to ask a few questions to start a discussion. Yes, if the dialogue gets in the weeds, yes, hopefully the advisor has a resource or two in, estate planning attorneys or whatever, where the advisor can say, that's a great question. I'm not the person that can directly solve it for you, but I can help you solve that problem. I've got some relationships. I've got a relationship where I can provide, a role in helping you take advantage of the resource that I have, the attorney that I have a relationship with, and we can start a dialogue about getting that problem solved. Would you like me to help you? And of course, the client is going to say yes. They know they have a need. They know they have a concern. Maybe they're even sleepless at night. But I feel like that's the best way for an advisor to start the process, one client at a time, ask some basic questions, be a good listener, and then have a resource that's available that you can be a participant and you can engage in, so that it just winds up as a win-win-win for everybody. So that's my thoughts on getting started as an advisor in the estate planning process. What are your thoughts there, Jacob?
Yeah, I mean, I think, whenever, for example, I'm opening a client account, we've got to get their personal information, open that account, right? And then, we have to name a beneficiary. And technically you don't have to, but I require it, at least a primary, and always recommend a contingent as well. But we have to name a beneficiary of an account. So that at minimum says, hey, who do you want to name as that beneficiary? Is it a spouse? Is it a child? If so, how old is that child? Okay, so we can kind of keep going down this little rabbit trail of actually me gathering information, like you said, asking questions, just being a listener. And then what that does, or should do in my mind, is prompt additional questions and say, okay, because of this, and this, or maybe this is our second marriage and we have kids from a previous marriage. Okay, so do we want it to go to our kids or our current spouse? Is there what's the deal there, and what happens if one thing happens versus another? And so the complexities of it are always there. And regardless, as an advisor, I have to ask the question, who do you want to name as a beneficiary? So it opens the door immediately, because it's simply a requirement on my end. And then from there, just as my job is to kind of facilitate that and say, okay, maybe there's additional things to ask here. But part of that comes from, those questions, they come from, I have to know at least enough to kind of know what to ask, if you will. And so going back to just real quick, I mean, that's what I've watched your channel quite a bit, and it's been super helpful for me, right? Because I have learned, hey, here's the things that we should pay attention to, at least at the surface, and then bring in those trusted professionals outside of that. So, that's one thing, is just we're already asking the questions. The next step is just taking that step to take it to the next level.
Yeah. And let me share kind of an example or a story of how, the financial advisor is asking the questions about beneficiary designation. The lawyer is talking to the client outside of the financial advisor's presence about how the client wants to leave the estate. And sometimes it's kind of as a default, if the advisor has a client with a $2 million life insurance policy or a $3 million brokerage account, and they're filling out TOD designations, it kind of happens by default. And let's say it's the blended family, kind of the Brady Bunch family, where you have each spouse has children from a prior marriage or a prior relationship. But when that account is being opened, and there's lots of things to do, and maybe the advisor asks, how do you want to set up your beneficiary designation? And that client might say, well, let's name my spouse as my primary beneficiary, and let's name my kids as the contingent beneficiaries. And everybody kind of thinks everything's fine. And then they come to me, and we just kind of part of my job to get deeper into that conversation.
Yeah.
And maybe when I have that conversation, it turns out that really what the client wants is, when they pass away, that $2 million brokerage account. They would want that account to go into a trust for the benefit of their second spouse, for example. And so the second spouse can get benefits from that $2 million brokerage account. But really what the client wants is, they don't want to leave it directly to the spouse, because the spouse may leave it to the spouse's kids. They want to leave it to a trust and provide for distributions to the spouse for the spouse's needs. But when the spouse later dies, those assets need to revert back to the children of that first spouse to die, that original account owner.
Right.
So my thought is, boy, if the advisor is a participant, and we'll talk about how this occurs in a minute, if the advisor is just even just a fly on the wall in that lawyer and client conversation, now that advisor can say, boy, I got it. That's a great idea. And so Paul or attorney, let's work together to make sure not only the will, the trust, and all that is set up properly, but let's collaborate on exactly how these beneficiary designations should be structured, so that it's consistent with what the client has in their estate planning document. So I've got 1,000 stories like that. And
one thing I'll say there too, real quick, is that, often the disconnect, and that's part of the problem here, is there's a big disconnect. And so you got a estate planning attorney doing one thing here, an advisor doing another thing here, and there's no collaboration. Let's say I have a client, I refer them to, an estate planning attorney, send them their way, tell them I sent you, right? Well, most of the time, I never hear back from that attorney saying, hey, we got this done, and here's what needs to happen on your end. But I also never hear back from the client, because they think, oh, everything's good, we're done. Yeah. And so for me, it kind of falls back into my court to say, hey, I've got to go follow up on this and see what happened, and get a new trust document if one's been created, or updated wills, or whatever it has just to have on file, and see with the client, hey, do we need to rename beneficiaries here? Like, what needs to change, if anything? And so the communication aspect is the misconnect or the disconnect oftentimes. And so working together, again, that's the key, is like, how can the attorney and the advisor work together to get the best result for the client? Because another example would be, new client comes in, I say, hey, tell me about your estate plan. Do you have a trust will? How's that all set up? Things like that. Yeah, I've already got that taken care of. Don't worry about it. Okay, well, that's great. I'm glad you have it taken care of, but we probably need to review that and at least take a look, because that's going to be instrumental in some of the decisions we make. And so on my end, I kind of have to insert myself a little bit and say, hey, look, I'm not an attorney. I don't claim to be or pretend to be, but this stuff impacts everything we do so much, whether you think it does or not. And so we have to kind of be completely open in all these things. That way we get the actual result you're looking for.
Yeah. Yeah. I think, and look, some people try to do the estate planning, kind of do it yourself. They don't want to hire an attorney. Some people want to do the financial planning piece by themselves. They don't want to hire an advisor. And look, I respect everybody's decisions, whatever they choose. Yep. But I do really feel like if that financial advisor can be engaged in the process, and that's what's next, then it's just, boy, it's an extra pair of knowledgeable eyes that just eliminates the risk that mistakes are likely to happen. So what I want to do is I want to jump into what the mechanics of how this can work. Because look, clients are busy, financial advisors are busy, lawyers are busy. They're all have their homes, their offices, they're all in different places. How in the world can they collaborate? So I don't know about you, Jacob. Maybe you'll tell me your story in a minute. But when I'm probably telling you more than being real efficient here. But when COVID hit, and back in March of 2020, it really drove me home. And so everybody, for a matter of weeks or months, and they were, you had to stay at home. And so it really forced not only me, but our clients, many of whom were elderly, to start using technology, like Zoom calls and video calls. It was kind of it would seem like before COVID, if we had drafts of a will for someone, and they read the draft of the will, and they read that maybe someone's middle initial was listed incorrectly in a document, they would call the office, set up a meeting. We'd have a meeting. They'd come into the office at a prescribed time. They'd tell us that the person's middle initial was incorrect in the documents. And it was just every piece of the estate planning process had to be done face to face. And so I really feel like COVID changed that. It forced us to take advantage of some of the technology like we're using today. And we really immediately went to Zoom stuff. And really at the same time, I have this YouTube channel that kind of took off, and we were getting, inquiries from all around the country, as we do. And so I know, Jacob, your business is similar. We've talked about your clients, from all over the country, just because you do a good job educating people on your YouTube channel as well. And people are starting to get to know you and like you and trust you. So all of that leads me to making it easier for advisors and attorneys to collaborate with the client to create this win-win-win opportunity. So just to give you a little idea of not that my business is the best estate planning lawyer business in the world, but let me just give you an example of how it has worked out. And I think it's helped the financial advisor community, the lawyer community, the client community is we now conduct, especially because we have this national law firm and our clients come from all over the country. And we have our co-counsel relationships with lawyers around the country who participate in the process that enables us to help people all around the country. But our meetings are primarily, 100% video meetings, like Zoom calls. And I know a lot of yours are too, Jacob. And I know, all of the advisors out there, many of their meetings are conducted via these electronic calls and video calls. So, boy, what a great opportunity. And it just makes it easy for the advisor and the attorney to collaborate with the client. So what we do, not that our business is the greatest, is we give our kind of financial advisor partners a calendar link to my website where they can just set up a Zoom call. They're the one talking to the client all the time, and they want to see that the client gets good service. And by the way, I will mention, probably a point worth mentioning, I think another reason advisors don't engage in that estate planning process is because if the resource, whether it's an estate planning attorney or a law firm or whatever, provides poor service, well, that's a poor reflection on the financial advisor.
I agree. That's one of the biggest things is whenever you refer someone to someone else, they're the ones that aren't going to look bad. You're the one that's going to look bad if you make that referral, right? So that's really the hardest part on my end, and has been, I would say, a struggle to an extent, is how do I find the right person, whether it be CPA or tax repair relationship, or an estate planning attorney relationship? How do I find the right people to partner with that do really good work, can be trusted, but also reflect well on me sending a client to them, because that's my client. Like, we're still going to be working together, and so I don't want to have that built into that. So yeah, I agree 100%.
Yeah. Now I know attorneys have this reputation of providing outstanding service 100% of the time. That's a joke. But yeah, no, I think it is a concern. So one of the ways kind of our office attempts to alleviate that is, if I was, fortunate to have a conversation with one of Jacob's clients, I'd be, Jacob, look, for a lot of reasons, I think you ought to be a participant in that discussion. Let's all hop on a Zoom call. You'll be part of every conversation. You won't necessarily lead it. Hopefully, the attorney does their job.
I don't want to.
Exactly. But it totally eliminates the possibility that behind your back an attorney gives poor service or says something inappropriate that would serve as a poor reflection on you. So for a lot of reasons, number one, you get to be right there in the Zoom room, for lack of a better term, in all of those discussions, and that enables you to contribute. You might spot something. You might say, well, look, hey, client, Mr. Client, you told me a couple of months ago that this is what you wanted, but now you're saying this, and I just want to make sure that we get it exactly how you want it. So that financial advisor can provide their perspective. So with our our financial advisor partners, I don't know if invite is the right word, or encourage, or even require that advisor to participate in those meetings for all of those reasons. So, and especially to the extent the client wants it, which they always do, they want that financial advisor participation. Now we're able to collaborate, mistakes aren't made. We're able to communicate, hey, advisor, these accounts should be titled this way. These accounts should be beneficiary designations listed this way. Look, advisor, client came up with some other accounts that they really didn't even realize they have. Maybe we can consolidate those. Maybe there's a need for some life insurance product or long-term care product that the client has mentioned that they'd like to take a look at. So many things work well when we do have that advisor participation. Yep. If any of you advisors are working there is, all of the large financial services companies in the back of their mind, they have this unauthorized practice of law concern. We don't want the advisors crossing that line where they could be in jeopardy of violating some unauthorized practice of law rule. But with an attorney guiding the whole process, with an attorney creating all of the documents, and you just being a participant and engaged in the process, it really eliminates any kind of unauthorized practice of law concerns. So that's generally how we've set up our business, taking advantage of technology, inviting advisors to participate for a lot of reasons. And the main reason that we encourage the advisor participation is simply because it's in the best interest of the client to do so.
Yeah.
More likely that their objectives will be met, not only their investment objectives, but their overall wealth planning objectives will be met with that advisor having that participation. So that's how we've set it up. I'd love to hear kind of your thoughts, maybe your business process on how you envision things moving forward in the financial advisor, estate planning attorney community.
No, I love it because that's it's huge. If we could all sit in the same room and just kind of hash it out, it's wonderful because, Paul, you could be meeting them for the very first time and I could have been working with them for 2 years. And so I know kind of them as a personal level, the ins and outs of what they mentioned to me on who they want their money to go to and how much and why and when. And you're meeting them for the first time. And so they could be having a different week and they're like, they feel one way that week. Right. And so it gives me the opportunity to kind of say, hey, you mentioned that last year, remember? Is that not the case anymore? Just like you referred to earlier. And we can really kind of figure out what the right solution is rather than them telling you one thing and then telling me another thing. And then we're like, Paul, this is not what I understood, if we're doing it separately. So being together in the same room, having that conversation helps, number one, helps you ultimately as the attorney understand what's going on, because I can help guide that conversation. Hey, remember, Ms. Client, we said this, and here's why we did this way. Is that still the case? And Paul, here's why we did that. Is that right or wrong? And so that's one thing. And then at the end of the day, if the client knows that their two professionals are working together, they can go home and sleep at night knowing that everything is right. I think sometimes going back to that, miscommunication, you go to a estate planning attorney, you get your documents created and prepared, and then nothing changes on your, brokerage account, let's say, or you don't have those assets moved into a trust, or you don't name, or you don't change the TOD designation or whatever it might be. It's like, well, it's still wrong. Even though you created this thing, it's still wrong. And so working together all, helps solve all that. But for me and kind of my business, the virtual solution is wonderful because most of my new clients are not local. Due to different marketing things and podcasts and YouTube, and people are kind of everywhere now. And so even my local clients are like, Jacob, I'd rather not come to your office. Can we just do a Zoom call real fast? I mean, it's a lot easier for me to do that. So yeah, I'd say 85, 90% of all clients I work with are virtual pretty much. We do Zoom calls for meetings or phone calls for quick check-ins. And it makes it easier to work with anybody and everybody. And the best part about what you're doing, and I know you're going to talk about this here in a second, is that you can work with clients pretty much throughout the country, minus a few states. And that's super beneficial for an advisor like myself, who is outside of my home state and works with clients kind of everywhere. So I can provide a solution to my clients without having to go source a local person I don't know, if that makes sense. So it's a win-win for everyone involved.
Yeah, great. So, well, since you brought it up, I guess I'll mention a little bit about my business. So yeah, real proud of what we've done. It's fun for me. I spend pretty much every weekday afternoon just meeting new people from around the country. And what happened was a few years ago when my YouTube channel kind of took off, I was getting requests from all over the country. So we set up this national estate planning law firm. We have our office and great attorneys, great staff in our office, which is in Louisiana. And then I've recruited and vetted these, what I call co-counsel lawyers in the various states from Florida, New York, North Carolina. I was on with one from Missouri today. And so when our clients work, I usually conduct these initial meetings with the advisors and the clients, and then we have a plan in place. We get things prepared. We get the co-counsel in the appropriate state to participate to the level that they need to. And so it's works out great. And so we're real excited about moving forward. What I want to do is, I know those of you who are watching on my YouTube channel, I want to address, because I always do some comments. Jacob, you okay with that?
Yeah, go ahead.
Yeah. So of course we've got Ann, we've got all the usual hellos we get on all my live streams. Darlene, Larry. Larry is the man. He's been on every live stream I've ever done from Bakersfield, California. Love to have you. Love to see you here. Whiskey Business is here. He's another regular. Okay, let's see. And Ann didn't realize one was happening. She stumbled on it. Yeah, it's because I couldn't announce it on my channel for some technology issues. Austin Fly Girl, love to learn, still going through tough stuff post being a new trustee with no knowledge about or all the things, also a family biz, which is blowing up. All right, well, good luck with it. And then Ann, totally understand. Paul's channel helps out a lot. Fantastic. Ann always gives me the smiley face with the hand emojis. Always love seeing that. And Aaron also more. And then hello from Texas from Donna. So, all right, that enabled me to get through my chat. Love the people when they put in the chat. That's why I love doing the live streaming, to get a little bit of kind of community involvement there. So
yeah, and Paul, we're doing it on your channel and mine, and so I say, hey, ask questions for me or Paul or whatever. I mean, I know a lot of these folks are from your channel, so feel free to tell them to ask me whatever questions they want. I'm an open book, so happy to answer anything.
Yeah. So this is the first live stream we've done. We hit it off at first sight, Jacob and I. So really just stay tuned. I look forward to doing more with Jacob. I've had this financial advisor community in my mind as to, how can we contribute content to, ultimately help more people, whether they get help from Jacob or myself or others. We just, we want people to be informed, make good informed decisions. This subject is so important. So I look forward. I'm glad Jacob and I were able to start talking and met each other and developed into this first live stream. And I'm looking forward to more in the future. And yeah, if you have some potential topics or questions that you'd like to address either now or on a subsequent live stream, throw them out there to us. We'd be happy to address them. So Jacob, any final thoughts?
Yeah. I got a couple things that came in here. One from Tony, just threw that up there. Great collaboration. Thanks for all the helpful info. Awesome. Tony, glad you're here. And then we got one from, looks like maybe Wyatt, looks like for you, Paul, can he review an already established living trust? So that might be a question for you there. Yeah.
So yes, we do. If someone has a trust, big part of our business is doing restatements of previously created trusts because, of course, family circumstances change. So our business process for that is you can go on our website. It's aeplawyers.com. You can fill out a little questionnaire. And in that questionnaire, you'll have an opportunity to say, yeah, I'd like to have someone review my trust. We'll send you a calendar link along with a portal that you can register to upload your existing trust. And then we'll be off and running. We'll review it, have that Zoom call with you, and see if we can figure out, what you're trying to accomplish and the easiest way to get there. Yeah. And this is actually somebody I know here. He's a client of mine, so he's asking that question. So I know who that is now, and I think we're meeting next week sometime. So we'll get that scheduled maybe. Maybe Jacob, we'll all be on that call together. There we go. Well, Paul, I know we got some other questions maybe coming through, so anybody feels free to do that. But a question for you on the advisor side might be this:
what are the what are the problems or issues you run into as an attorney that advisors create for you? Is it, hey, we don't want to share information, we don't even bring up the conversation? Like, what are all the things that we do to create more problems for you as an estate planning attorney?
Yeah, so I'll break that down into two answers. One is because I don't feel like I'm answering it properly if I just don't address the elephant in the room. And the elephant in the room is those advisors just aren't taking advantage of this opportunity that they have to help their clients. And it's for any number of those reasons that we discussed. They're concerned that if they do, send their client to an attorney, the attorney might deliver terrible service, and it's a poor reflection on the advisor. What I've seen is most advisors, because it's either the way they do it or it's because it's the way they've been instructed to do it by someone, is when the client does ask the advisor, hey, advisor, I don't have a will. Can you help me?
Yeah.
The usual response that I've seen is advisor says, sure, here's 2 or 3 attorneys that I know, that I have a relationship. Here's their name and their phone number. Give them a call. Let me know if you need something. And then it goes just like you said, Jacob. The client goes off, has conversations with the attorney. Who knows how it's going to turn out? There's no collaboration. So I think when it goes wrong, it's the bigger picture of the advisor is not taking advantage of the opportunity to help not only the client, but help themselves participate in the estate planning process. And then on the other hand, it's sometimes they, at least in my view, they participate a little too much. I'll be guiding a conversation and I'm sure I'm not the world's greatest estate planning attorney, but I've done it for a very long time and have a lot of these conversations, thousands of them, probably 10,000 or more over the years. And then sometimes a financial advisor will kind of hijack the conversation. And maybe it's because they maybe want to demonstrate that they know some of the subject matter. Hey, Paul, what do you think about creating a Cupert, Crat, Grat, Grut, Charitable Remainder Trust or ILET for our client? Yeah. And then I'm just like, I want to just go boom, because now what's the client thinking? The client's thinking, am I missing something? And they just brought up, 7 or 8 suggestions of very complicated estate planning tools that probably I thought didn't apply to the client's particular circumstances. So that it makes everything complex. We like to keep things simple. My advice to the advisors, if you see that the attorney, me or anyone else, if you see that something they're doing just doesn't sound right, maybe instead of addressing it in front of the client, maybe address it privately with the attorney after the meeting and say, look, attorney so-and-so, I didn't hear you bring up this, or I thought you might bring up that. And then there, you can collaborate, have a discussion. And if somebody did that to me, I might say, hey, that's a good idea. Maybe I'll bring that up, or maybe we'll talk about why it really doesn't fit that client's circumstances. So on the other hand, as opposed to where does it go wrong, it's lack of engagement and kind of hijacking the whole process. Where does it go right? When there is advisor engagement and the competent attorney leads the process with the advisor being a participant and engaging, in the communications.
Yeah, because we see the custodial accounts, we see where the money is and which accounts we have open, and so we're able to kind of fill in the gaps, if you will, on some of the questions you might be having. Hey, where are all these assets at and what's going on with them? It's like, oh, well, glad Jacob's here to help navigate that a little bit. Good. Awesome.
So, yeah. And all of this stuff that we've been talking about, it's the need is going to be even greater because of legislation that state governments and the federal government have been passing. So, when I first started out 3 decades ago, people had their beneficiary designations for their life insurance policy and their IRA. And then now state legislatures have and whether it's good, bad, or indifferent, it's good in many ways, but it can be abused. Now, state legislatures across the country have enacted, TOD designations on brokerage accounts, POD designations on bank accounts and credit union accounts. Some states have created TOD deeds so people can title their house and name a beneficiary when they die. Many states are enacting legislation enabling people to title their vehicles in a way so that when they die, it automatically gets transferred to a beneficiary outside of probate. Many states have legislation where if someone owns a business or an LLC, they can title that LLC in a way where the ownership goes, automatically to that beneficiary. So more and more assets these days, and will continue to be in the future, are passed, outside of that will or trust that the attorney is involved in. So it's just another reason where the advisor who's having regular communication with that client can spot these things, sometimes spot mistakes, and get the attorney involved to clean that up. Sometimes on TOD registrations, we'll name a trust as a beneficiary. Sometimes on a brokerage account, we'll name a trust as an owner. But unless you get that attorney involved, that best solution may not be there. So the problem is just going to magnify as these additional tools get created to enable more people to pass more assets outside of probate without attorney involvement.
Yeah, that's awesome. That's wonderful. And to that point really quickly, I know this may be slightly off topic in terms of how advisors and estate planners can collaborate, but for my listeners on my channel, on my end, educate them slightly, and educate me too, is you got a brokerage account, let's say, you can name it on a TOD, you could name the trust as the beneficiary, or you could have a trust account with those assets inside of it. What's the difference, and why does one maybe better or worse than another, or is there an option there?
Yeah, my view is that the differences are subtle.
Okay.
So, for example, if you have a TOD account that names a trust as a beneficiary, that account is in the individual's name for the rest of their lifetime. Could be some issues in the event the client becomes incapacitated. Now, if the client has executed all of the power of attorney, durable power of attorney stuff, then upon the client's incapacity, that person that they had designated on a power of attorney can then step in and transact it. Some financial institutions are a little reluctant to honor powers of attorney if they're worded a certain way or they're too old. If that account is titled in the name of their revocable living trust now and they become incapacitated, then that successor trustee can typically step right in and manage that account throughout the trust settlor's incapacity. Again, a subtle difference. I think you're probably, in most cases, 95% of the way okay by just making sure that trust is designated as the TOD beneficiary.
Okay.
So it's just, some subtle things there.
Yeah. Awesome.
I'm getting a bunch more activity, Jacob. Will let you want me to hit it?
Keep going. Yeah, let's go.
Okay. All right. Oh, Larry, my man, Larry just subscribed to Jacob's channel. That should Jacob, you hit the jackpot today.
Larry, welcome. Glad to have you. It's going to be awesome. Glad to have you.
Larry is my favorite YouTube watcher. Okay. Not that the others are not my favorites. Loca Mocha. Hi, Paul and Jacob. Have you ever had a situation with a child-free couple who would like to leave most of their funds to minor nieces and nephews, and the majority of these funds are in an IRA? Great question. So yeah, from my end, you're leaving things to minors, and if you leave things to minors but they're not children, then those new Secure Act rules say that they have to take those distributions within 10 years after you pass away. If they were children, their 10-year period doesn't start until they're 21. But if they're not children, the 10-year period happens right away. So always going to be best if you leave those assets in a trust for the children. That way, when they're 18, they don't get to just grab it and pay the taxes and run. But you do have to seriously consider these required minimum distribution rules on when apparently when you're leaving things to people other than your children. So that just requires a whole nother discussion. And
Paul, on that one there, sometimes I've heard, well, I'll just leave it to, if it's, I guess it might be brother or sister who's the parents of those nieces and nephews. I'll just leave it to them and they'll take care of it. That's what, because I'll leave it to them as a beneficiary, and then I'll put in my will that I want that to be for the, the kids, the nieces and nephews. And it's like, well, technically once they receive that money, that's their money, right? So it's a, what do you really want to happen, and getting that set up correctly on the front end.
Now, if you want your IRA to go to your sister's 4 young children, and you want it to go to the 4 children, you might just think, well, I'll just leave it to the sister and she'll give it to the 4 kids. Well, by leaving a traditional IRA to your sister, now your sister has to pay income tax on all those distributions whenever they take them, and that just confuses everybody. And so, yeah, there's a right way.
Probably on a faster schedule too, because those minors, like you said, if they're under 21, they don't have to actually have that money out. That 10-year clock doesn't start until they reach 21. Then it goes at that point. Yeah. So,
and a little asterisk of that rule, that only applies when the beneficiaries are children. If the beneficiaries are not children and they're 14, their 10-year clock starts right away. So that's a little
again, confusing stuff.
All right, so let's see. Austin says, hi, Donna. Okay, fellow, let's see, good one. Francis says, hi, all. I would really like your advice on getting a living trust. I know at my age 70, having a house and other assets, I need to get a living trust, but I'm not sure how much and to whom I would want to. And I think you got cut off because it was too many characters. So quick note on that, Francis, and maybe get Jacob's perspective on his clients who have either created or not created trusts. The whole idea there is, if you leave assets in your name, not necessarily assets where you have beneficiaries designation, but you mentioned you have a house. When you pass away, if those assets are in your name, then those assets are what I say frozen, and your survivors will have to hire lawyers like me. We've got to go through a court and attorney involved process called probate, which most people perceive as expensive and time consuming and an all around hassle. But nonetheless, it's done all of the time when people die with assets in their name. So the idea to combat that is create your living trust, and trust really serves as a replacement to your will. Your trust says who handles your trust when you die, who are your trust beneficiaries to inherit your trust assets when you die. And you go ahead and retitle your house and other what we call probate assets to your trust. Things that are in your trust when you die, they don't have to go through this court and attorney involved process. Your successor trustee can immediately start managing everything, make the distributions to the trust beneficiaries outside of that court process. So that's the idea behind creating a living trust. Maybe you, Jacob, if you've had, share some experience on your clients, whether they were successful, if they wanted to avoid probate, how they did it. What are some of your thoughts there from an advisor's perspective?
Yeah, Paul, the most common thing I hear is, Jacob, I already have my estate plan set up because I've already got my will. And that's great. We want a will. We definitely need to have one. But that probate thing we talk about, that's a big deal, and takes a lot of time, money. And for me personally, one of the things is it's a public thing. It's not private anymore. So your assets are no longer private, or who gets there. Public can find out who got them and how much and when and all that sort of stuff. So a trust, like you said, is almost a replacement of that will, and is a more efficient tool to do that, because now you don't have to wait. Your assets are not frozen. You can sell the house the next day if you're that trustee, all those sorts of things. And so the trust is the way to go in, correct me if I'm wrong, but many situations where, it's like, hey, I'd just rather keep that private and make it immediate rather than have to wait a long time and spend money and really go through the court system there.
Yeah, I was dealing recently with some children. The husband passed away a couple of years ago, and they're going, and it was a wealthy family, and they were, they just didn't, when the husband created his will, I don't think the lawyer even mentioned probate or avoiding probate or setting up a trust. So he did his will and he died, and probate's still going on. Lots of assets in the public record, a lot of assets. And now the kids are saying, my mom would not want all of our family's assets that they worked so hard to accumulate in the public record. We need to make sure that, when mom passes away, we want to keep this as private as we can. So good point there. Let's see, Donna, we talked about this earlier. I found out too late about the fact Texas allows car titles to transfer upon death. So that's just more of that legislation that's being created. where the advisor who has more contact with the client can spot these things and make suggestions. All right, we got a lot of let's see.
And Paul, real quick on that, it's an important thing because I don't get paid to advise on a car title, right? But it falls into this realm of all the things that relate to someone's financial picture. And so as a comprehensive advisor, which I try to be, all of it matters. And so going back to that, it's like, hey, Paul, I don't know about these rule changes. Can you just educate me a little bit? And then I can communicate that in a quick thing to clients or whatever it might be. So again, I think it has to be collaborative, but also comprehensive, because that is a big deal. It could be a small thing such as a car, but could create a lot of headache for whoever is supposed to be getting that one day.
Yep. Got more fans of Jacob here. Austin Fly Girl says, "What's your channel, Jacob?" So give a shout out. What is it?
It's just at Retirement Answers there on YouTube. So you could do YouTube/@Retirement Answers.
Okay. And I guess if they just also did a search for Jacob Duke.
Probably so. Yeah.
Too. Yeah. All right. All this, everybody's becoming a Jacob fan. Let's see here. So the beneficiaries must be 21 years of age. I'm not really sure. That was probably in response to something else. You're welcome, Loca Mocha, for answering your question. You gave me a smiley emoji for answering your question, and good points there. Probate when it is done, and the trust is all must have a will. Can't a trust work? No children, unmarried. So yeah, a lot of stuff there. But if you leave a Roth to a sister, there are required minimum distributions from a Roth, but it all comes out tax free. So So I know Jacob deals a lot with Roth and Roth conversions and all that good Roth stuff. So, all right, Jacob, I think we're going to wind it up. I don't know about you, but I had a good time, and I thought it was a real success, and look forward to sharing some more of our wisdom that we have to those who we can maybe provide some small contribution to helping them help themselves and their family.
Absolutely. Yeah. Erica she said just dropped in. Jacob, where are you practicing out of? I'm actually in Arkansas. I work with clients all over the country though. So no matter where you are, I can help at least in some way.
Yeah. All right. Very good. Well, look, we'll see all you guys next time. Have a great evening. See you around.
All right. Thanks, Paul. Bye, y'all.